Hello everyone. In today's video, we are going to cover the very important topic which is called the parties to the suit, which is given under Order 1 of the Code of Civil Procedure. So when we say that we are going to study this topic, there are few very important subtopics which we are going to study in this. First of all, we need to understand what is the meaning of joinder of parties, and then joinder of parties, you will find that they have been divided in two parts: joinder of plaintiff and joinder of defendant. Then we need to understand the concept of necessary party, proper party, the difference between both the concept, and then we will understand non-joinder and misjoinder of party, and so on. So let's understand the concept of joinder of parties. So as I said, joinder of parties is divided in two parts: joinder of plaintiff and joinder of defendant. So what is the meaning of joinder? Whenever there will be more than one plaintiff in the case, that becomes the case of joinder of plaintiff. And whenever there will be more than one defendant in any case, that will be the case of joinder of defendant. So it is not necessary that in every suit there only has to be one plaintiff and one defendant, or two plaintiff or one defendant. There can be multiple plaintiff and multiple defendant, and there can be one plaintiff and one defendant also. So under what condition the joinder of plaintiff will fall and how the concept will be attracted, that is given under Rule 1, and the relevant rule with regard to the joinder of defendant is given under Rule 3. So let's understand the very important expression which is used under those particular rules. So first, Rule 1. Rule 1 says who may be joined as plaintiff. There are two clauses, and you need to write down few expression because those are very important. It says all persons may be joined in one suit as plaintiff where any right to relief in respect of. So you need to underline any right to relief in respect of or rising out of the same act or transaction or series of act or transaction is alleged to exist in such person. You need to underline this: is alleged to exist in such person, whether jointly, severally, or in the alternative. And then it says, and if such person brought separate suit, any common question of law or fact would rise. So you need to understand in a simple way that whenever any right to relief will exist in more than one person in one act or transaction, that will become the case of joinder of plaintiff. And as per Rule 3, whenever there will be a right to relief in relation to same act or transaction against some other person, that will become the case of joinder of defendant. For example, there is a person called Mr. A. He enters into an agreement with B and C and agrees that he will deliver 500 tins of oil to B and C, but he does not deliver that. In that situation, both B and C can file the case against A. So here in this case, right to file suit existed in relation to same act or transaction against A. So both B and C becomes the plaintiff and A becomes the defendant. So this is the case of joinder of plaintiff. If I give you the example which is not a case of same act or transaction, so if I say that A enters into a separate agreement with B that he will deliver 100 tins of oil, and then A enters into separate agreement with C that he will deliver 100 tins of oil, and he does not deliver 100 tins of oil to anyone, neither to B nor to C. In that situation, one suit cannot be filed. They have to file a separate suit because here the case is not arising, the right to relief against A is not arising out of the same act or transaction. In a similar way, joinder of defendant is given under Rule 3. Now what it says, we need to understand the expression of this also. Any right to relief in respect of or rising out of the same act or transaction, it's going like in a simple way like it was going for joinder of plaintiff. Then it says series of act or transaction is alleged to exist against such person. Here the difference is only against such persons. In joinder of plaintiff, the expression was used exist in such person. Here it is used exist against such person. If I give you a very simple example, suppose now currently I'm sitting in my office. I go out and some 4 to 5 people come and they slap me. In that situation, my right to relief exists against all 4 to 5 persons. So in that situation, that will become the case of joinder of defendant. Now we need to understand the concept of necessary party and proper party before we go to understand the concept of non-joinder and misjoinder of party. So necessary party. Necessary parties are those parties whose presence is indispensable to pass any decree by the court. And proper parties are those parties whose presence is not indispensable for the constitution of the suit, but if those parties are there in existence, those parties are the part of the suit, then in that situation it will ease the process. It will help the court in final adjudication of the suit. I will give you a very simple example of necessary party and proper party. So suppose if you want to file a partition suit, you are 5 brother and sister. So one brother has filed a case against remaining 4 brother and sisters. In that situation, all 4 brother and sister are the necessary party in the partition suit, because if you have not made any of them party, then court in that time cannot pass a decree. Because in partition suit, all the brother and sisters have to be the party. But if in this situation, if you are making the children of those brother and sister as a party to the suit, they are the proper party. So you need to understand that making the grandchildren or granddaughters party in the suit was not indispensable. It was not required for the court to pass decree. But if they are there in the suit as a party, it will help the court in final adjudication of the case. Now let's understand the concept of non-joinder and misjoinder of party. But before that, we need to understand the relevance of this. So as per rule 9 of order 1, if it is a case of non-joinder of necessary party, your entire suit can be defeated by that. It means if in any case there is no necessary party, or if necessary party has not been made, if you have left any necessary party in the suit, your suit can be defeated, your suit can be dismissed. Then rule 13 says that any objection with regard to the non-joinder or misjoinder of parties have to be raised at the earliest stage possible, at least before the settlement of issue. And if you do not raise this objection, your objection with regard to necessary party or proper party, those objections can be waived. So what is this non-joinder? If I tell you that I have made 5 parties in the suit, and if I have missed one necessary party or proper party in that particular matter, in that particular suit, that becomes the case of non-joinder of party. Now I need to remember this non-joinder of party also is divided in 2 parts: non-joinder of proper party and non-joinder of necessary party. So in any case where, or in any suit where the necessary party was required to be there, but you have not made that necessary party as a party, or if you have not made that proper party as a party to the suit, in that situation it becomes the case of non-joinder of parties. And if the case of yours is in relation to the non-joinder of necessary party, then your suit can be dismissed. Now let's come to the point of misjoinder of party. Misjoinder of party is the case where you have made some wrong party who is neither a necessary party nor a proper party. So whenever you have made any wrong person as a party in the suit who is not necessary party or a proper party, that becomes the case of misjoinder of party. But you need to understand here that as per rule 9, your suit can be defeated only when it is the case of non-joinder of necessary party. So if you get any doubt in relation to any concept, whatever I taught you in today's video, you can just write in the comment box and I will try to clarify your doubt. See you in the next video. Thank you.